jury has joined us again. Welcome back, folks. I hope you avoided that rain. No? Well, in that case, I hope you had a boat, not a car. It was pretty bad out there. Thank you for coming back. Before we proceed with Mr. Bruckler's redirect examination of Dr. Reed, I want to remind Dr. Reed that he's still under oath. And then I want to remind you, members of the jury, that the court has admitted the testimony of Dr. Reed only for a limited purpose. You may consider this evidence only as to the issues raised by the defendant's plea of not guilty by reason of insanity. You shall not consider this evidence for any other purpose. All right, with that, Mr. Bruckler, you may proceed.
Thank you, Your Honor. Doctor, a couple things I just want to touch on before we get into some other bigger chunks here from the cross-examination. One thing you were asked about was the defendant's writings after the massacre involving galactic colonization. Do you remember that?
Yes.
And there was some discussion about those and what they might reveal. Were you aware from going through the discovery in this case that the defendant was a fan of science fiction?
Or at least that he read a fair amount of it in his cell, sure.
In fact, is there some evidence that suggests that even his mother had sent to him a book called Starfist, and maybe been the only book left in his apartment that was fiction, I'm sorry, Starfist, and it was some science fiction book. Do you remember that?
I remember the title Starfist. I didn't remember how he got it.
The idea of galactic colonization isn't one that the defendant came up with?
No, it's a common idea about our having to leave Earth sooner or later. It's not fit to live in or something like that. That's a common theme actually in science as well as science fiction.
There was a discussion of certain snippets that were taken out of the video where, in quotes, where the defendant says he looked in the mirror and saw maybe this other person. Do you remember that?
Yes.
Did you conclude, based on all the evidence that you reviewed, that the defendant had some sort of split personality or two different people were working in that one body?
No, there's no evidence of split personality, multiple personality, anything like that.
There's also some questions that involve the defendant continuing to say, I was on the mission, I had to complete the mission. Is there anything in the discovery that you found that would cause you to have the opinion that he was not acting voluntarily on the 19th and 20th of July? Sorry.
Objection. Relevance to the issue of sanity.
Sustain to the form of the question. Rephrase your question, please.
Yeah, thank you. In light of those questions about him feeling like he was on a mission, had to complete the mission, is there anything that caused you to conclude, in your opinion, that the defendant was not acting of his own accord or on his own will back on July 19th and July 20th?
Objection. Relevance to the issue of sanity.
Overruled.
Go ahead, sir.
Nothing indicated that. He certainly indicated that it was a strong wish or a strong impulse, a press, I'm not sure you use that word, to complete the mission, but that doesn't have any particular relevance with regard to capacity and things like that, in my view, in the way that he described it or the way that the record describes his behavior.
To the extent that others that we may hear from later have suggested that the defendant was in a psychotic break on the 19th or 20th of July, I want to ask you, can you circle a date on a calendar and say, this is when I'm having my psychotic break?
Not predictively. You can't say, I think I'll have it Thursday, if that's what you mean.
Okay. Or the 20th of July?
No.
There was also a question about the fact that the defendant had made multiple statements about wanting to be remembered, which led into questions about pictures. You had opined, you had answered the defense counsel that there was a Squarespace account that the defendant had access to, and then defense counsel had asked you about, do you know if he'd ever done anything to allow someone to have access to that? Do you remember that conversation?
I remember that conversation.
I would like to direct your attention, if you could. Do you have the copy of the notebook up there?
Not with me, no.
Can I approach the witness, Your Honor?
You may.
I want you to take a look at the very last page Page 56, way at the bottom. There's some envelope stuff in there, isn't there?
Sure.
Yeah, sorry.
This is a copy of the notebook that
Yes,
you
sir.
gave him? Okay.
Yes, sir.
The very last writable page of the notebook, yes, page 56.
Please look at the bottom, and if you could, ma'am, would you publish, please, 56 with a blow-up of that bottom portion? Doctor, this notebook, as you've said before, was written to send to someone else. Do you remember that?
At least at one point, it was sent to someone else.
And this last page, is this what appears at the very bottom of the last page of this notebook sent to someone else?
Yes.
Are you aware from the discovery that at the time that this notebook was sent, the defendant had already posted, "Will you visit me in prison?" on a couple different adult dating sites?
Yes.
Ma'am, you can take that down. Thank you. You were asked a number of questions on cross-examination about Dr. Woodcock and what you would do had you been in the position of Dr. Woodcock and sent into the jail. And do you remember all that?
Yes.
I want to ask you some specific questions to follow up on that. One of them is, if you had been given directive by an attorney to go interview a client, much like the person here in jail, and you were given 3 hours, tell me what you would have done to go about making that the best interview possible.
Assuming that I'd already talked about what's the context, etc., in those 3 hours I had with the individual, I would want to quickly form some sort of rapport as best I could. I would tell the person why I was there, who asked me to be there, and what the results of our interview might be, who might see it, things like that. I would ask some psychiatric questions, some introductory questions. I would fairly quickly, given only 3 hours, get to the events with which he was charged, or the events that apparently just happened, such as in this case a shooting, what happened right before, what happened during, what happened after, both the factual things and the psychological things. What do you think happened? How do you feel about it? Can you tell me more? That sort of thing. I would spend some time trying to do a more thorough general psychiatric interview as well, and mental status examination. But I would assume, unless the lawyer told me otherwise, that my reason for being there was to assess him for some legal, that is forensic purpose, either responsibility for the act or competence to stand trial, something like that, and carry that out as best I could in 3 hours, understanding that that would be a preliminary thing, that I'd need to do more things after that before offering opinions.
We'll get to what you might have done after that. A couple questions to take us back. I mean, outside of anything recorded by law enforcement shortly after the arrest or the crime, is this the best shot you're going to have to figure out what's going on in someone's mind after they commit a crime?
It's a very good shot, and you try very hard to do it, because once that time passes, the opportunity's gone.
For that kind of an interview, would you have wanted, if at all possible, to record it in the manner in which you've recorded these other assessments?
Oh, yes.
How about this? If you were going to go interview a person, whether it was under the conditions we've just described or any other, what limitations do you impose on who can be in the room with you?
I always prefer to do the assessment by myself. There are situations where you can't, where there's some legal reason that you can't, or a security reason that you can't. But usually, as I do and as I've suggested other people do, there's a way to be in private with the individual, whether there's a guard just outside the door or the individual is shackled, something like that. Having someone else in the room necessarily contaminates the interview to a smaller or larger extent. If a lawyer insists on being in the room or insists on having someone else in the room, if I wish to continue to work with that individual, with that attorney, then I will try to make sure that the other person in the room is out of eyesight, not in the line of sight of the person I'm examining, does not make any comments at all. I'll recognize that the person is there. It would be silly not to recognize that the person is there. But the person would be expected to be silent and out of the line of sight of the individual.
Why?
Because I want to get things from the individual. I don't want the individual to be guided either subtly or directly by the person in the room. And I don't want myself to be limited by a comment or a gesture from the other person in the room.
Well, let's go back now and talk about the interview that Mr. King spoke with you about, with Mr. Woodcock and the defendant. And we were...
Respectfully, it's Dr. Woodcock.
I'm sorry, did I not say doctor? I didn't mean to not say that.
I think he said Mr. Woodcock.
Sorry.
It's okay.
Dr. Woodcock. Dr. Woodcock, we weren't sure if you saw him on the 23rd or the 24th of July. Is that fair?
Something like that. It was within 3 or 4 days.
All right. Now, did he go to that setting and interview the defendant all by himself?
The
Objection
indication
calls for speculation.
Well, he's asking if you know. You can only answer if you know.
The indication from the record and from my conversation with Dr. Woodcock is that Mr. Bishop was in the room with them.
And do you know who Mr. Bishop is?
Yes, Mr. Bishop is an investigator with the defense team.
Is that already somewhat of a contamination of that interview?
It would be if I were doing the interview, and I need to answer yes to that.
And I should follow up. You spoke with Dr. Woodcock about the interview he conducted?
Yes.
Did you also review his notes?
Yes.
The very first report that Dr. Woodcock generated, do you remember when that was?
It was dated March 26, 2015.
March 26th of this year.
Correct.
Okay. In between the notes that were generated by Dr. Woodcock back in presumably July 23rd, 24th of 2012 and 33 months later, are you aware of any other notes or reports or anything generated by Dr. Woodcock related to this case and that defendant?
Except for his conversation with me, no, and I'm looking on the notes to see whether they were generated at the time of the assessment. It appears that they likely were generated July 24, 2012.
Okay. And you're not aware of any other notes or reports or anything else?
Prior to the March 26 quote evaluation report, no, I'm not.
Okay. So let's go back to talking about the defense investigator who was inside the room during this interview. Did you, from his notes and from your conversations with him, discover that he had done more than simply be there in the room?
There is indication in the notes on the second page of the transcribed notes. There are 3 words that I'm not sure exactly how to interpret. Question mark Bishop, cough, laughing. On a later page in the notes, there's a parenthetical note, SB, Stephen Bishop, dash, defend yourself, close parentheses. And my interpretation of that, and I believe that I checked it out with Dr. Woodcock, but I'm not absolutely sure, is that Mr. Bishop said something or interrupted in some way, and my note to myself is I wondered where he was sitting and whether he participated in any other way.
Suggesting that he injected an answer into the conversation.
There's a suggestion of that. I wasn't there, and you have to ask Dr. Woodcock what happened, or Mr. Bishop for that matter.
Based on your reading of the notes and the conversation with Dr. Woodcock, what concerns do you immediately have then about this particular interview?
Concerns about the extent to which, I'm just looking for other examples, I don't think I see any, concerns about the extent to which Mr. Bishop expressed his presence, and that presence was known by or influenced either Mr. Holmes or Dr. Woodcock. It certainly comes to mind that Dr. Woodcock may have had specific instructions from the attorneys, and Mr. Bishop may have been there to make sure everything went that way. That's speculation.
Okay. Now let's talk about then what you said would have been one of the most important things to get into, and that is the discussion of the crime. Tell
Sure.
us, based on this, what Dr. Woodcock discovered about July the 19th and 20th and the defendant's conduct on those days.
I didn't see really anything. Let me see if there's anything here. There's a lot about his history prior to July 24 or 22, I'm sorry, July 1920. His history about it, a lot about the way he gets along in school, gets along with others, Dr. Fenton's treatment of him. Interactions with friends, symptoms that he talked about, being, in Holmes' words, catatonic for days, things like that. Things about general interview questions like how do you sleep, any substance abuse, any accidents, your medical history, any hallucinations or delusions. He did talk about apparently the dying of the...
But I'm going to object to the narrative. I think the question's been answered.
All right, ask your next question, please.
And Judge, if I could just clarify, because I don't know, I don't want you, doctor, to go through every page, but did you, in your review of the notes and your conversations with Dr. Woodcock, discover that he asked anything about the crime on July the 19th and 20th of 2012?
There is an area that implies that. It's on page, I don't have a page, it's on page 13 of the notes, in which Dr. Woodcock appears to be talking about assessing competency of the person, I assume trial competency of the person, and has apparently asked about...
Doctor, could I cut you off there for a minute?
Sure.
In terms, other than this section, which seems to be very procedural, you don't see anything in there, I'm going to lead you a little bit on this, you don't see anything in there where he went through some sort of detailed recitation of the defendant's planning, the booby trapping of his apartment, or the murders he committed in the theater?
No.
There are some areas that you did reference, though, that he does discuss with him. And does it appear from these notes that the defendant was able to communicate pretty well a couple days after this thing happened?
Yes.
Pretty good memory?
Assuming that what he says is accurately as it happened, and I'm not sure that... well, yes, it seems accurate compared with other parts of the record, so I'll say yes, pretty good memory.
Does he indicate in there to Dr. Woodcock what relationship he was trying to have or not have with Dr. Fenton and Feinstein?
I don't believe so.
Take a look at page 5 down towards, well, last kind of paragraph, if that's what you can call it. Do you see what I'm saying? This begins initially.
He refers to not wanting to build a false sense of support, apparently with Dr. Fenton. I think that's about it that I see here.
Got it. And by the way, the false sense of support, that is a transcription of the handwritten notes of...
Yes, I'm happy to go to the regular notes because I have them as well.
Well, look, I couldn't read them. I'm not going to ask you to do it. What I will ask you this, though, is in the notebook, Do you recall a similar sentence of don't build a false sense of rapport?
Rapport. Yes, if you'll give me just a minute, I can.
Sure, sir.
I believe the transcription was Dr. Woodcock's own.
I don't think so.
The whispering thing usually works better if you don't have a mic on.
I just Dan King to myself, Judge. I'm sorry.
I'm not quickly finding it, I'm sorry.
That's okay. Let me ask you, since you're going through there, do you find any reference to the notebook in there?
No.
You do see a reference to 3 plans, Plan A, Plan B, and Plan C. Do you?
Yes, yes.
Tell us about that.
And the concept of Plan A, Plan B, or Plan A, B, and C comes up elsewhere as well. At various times, and here as well, Mr. Holmes described Plan A as succeeding at the therapy, at the treatment, apparently by Dr. Fenton. Plan B was
Page 7, sir.
thank you,
Bottom.
a biological weapon. I think it's reasonable to infer doing violence or killing people with a biological weapon. Plan C was, quote, what I did.
Can you go to the next page? At the top. Does it appear that there's some discussion about whether or not the defendant considered going on to an antipsychotic drug offered by Dr. Fenton or Feinstein?
Judge, at this point, I'm going to object. This is well beyond the scope of my direct examination. I asked some hypothetical questions of the doctor of what he would do in a similar situation.
Overruled?
Thank you. Go ahead, doctor.
He talks about option C was all I had left. I'm not sure that's responsive to your question.
It is. Here's what I want to ask you. That first part. When recommended to go on antipsychotic the Monday after the preliminary exams, what does it indicate the defendant told Dr. Woodcock?
The notes, which in all fairness are short notes and perhaps don't convey everything that was said, indicate that he thought about it having a possible effect on his educational future. That may be Dr. Woodcock's comment. What future would I have if they took away Plan C?
And Plan C is what we're here to talk about, right?
According to these notes, yes.
Further on down the line there, on those set of notes, it indicates there something about recruitment. What did the defendant tell Dr. Woodcock about that?
Objection to what the defendant told Dr. Woodcock. He can report what's in the notes and what he heard from Dr. Woodcock.
That's.
Objection is sustained.
I'm sorry, Your Honor. I didn't mean to talk over you. That is fair and that is accurate. Doctor, what does it indicate the defendant told Dr. Woodcock in his notes? Same page.
I remember the short note says dash in a way dash tried to recruit friends dash in grad school, not explicit, quote, join me to kill people. That is, he didn't say join me to kill people. He had asked them if they shared his philosophical view. Dr. Woodcock apparently asked, how did you put that? And the next line reads, I hate everybody.
Hang on. I hate everybody are the words?
Those are the next words in the notes.
You see anywhere on here the word aversion, dislike, or broccoli?
No.
Further down there, there's something that appears to be a poem or something like a poem that starts off with O. You said O-H?
Yes, yes.
Does that also appear to be Dr. Woodcock's notes about what the defendant told him?
It appears to be, I don't know the context.
Tell us what it says.
It says, They responded, he is depressed, inwardly directing his suffering. Oh, it's my fault. Oh, woe is me. I'll release havoc. Only told 2 people, not a strong reaction. He was testing the water to avoid jeopardizing his objective.
Got it. On the next page, page 9. He references on there about 4 or 5 lines down something about numbers. Is that it? What is that in reference to? What does it appear to be in reference to? Or based on your conversations with Dr. Woodcock, what it's in reference to?
I turned them into numbers. Woodcock, it appears that Woodcock said, "What do you mean?" And then he apparently said something like either dead or alive. He goes on to talk about, were they specific numbers? More than 2. It is not clear what he means there. One can draw the inference. I would say speculate.
Judge, I'd really object to any speculation.
Sustain.
Yeah, and I won't ask you to do that, Doctor.
Okay.
I will ask you, though, if there's anywhere else in there other than that reference to I turned them into numbers. Is there any discussion at all of human capital or transference of experience or anything?
I'm looking for any reference, particularly with depression getting better. I'm not finding it. I'm not finding anything else here that's responsive to what you ask about.
So you didn't find anything in there about human capital or?
No, certainly nothing about human capital. I was wondering if there were, though there's a comment on page 7. He decided not to do suicide, would do homicide. That's about as close as it gets, I believe.
Is there a section in here where it appears they have an exchange about different ailments or things that he's seeing or hearing, anything like that?
Yes.
Yeah, in those pages, is there, and this is again, July 23rd, 24th, does it appear that there's any reference in there to audio hallucinations?
No reference to auditory hallucinations, hearing voices, that kind of thing.
How about shadows?
No.
There is a reference to the end of his romantic relationship on page 13.
Yes, toward the top.
Yep. Does it indicate how he described himself during the relationship?
Objection, beyond the scope, relevance.
Overruled.
Go ahead, sir.
Not specifically. It's just kind of different words or phrases. I can read it if you like.
Is one of those words happy?
One of the words is happy, among others.
So does it indicate how he described it to Dr. Woodcock, how the relationship ended?
What it says is...
Objection calls for speculation.
He can read what it says. Do not interpret it, okay?
Yes, sir. It says under romantic, online dating doesn't work, friend in past, difficult - happy, 3 or 4 months, ended 1 week later, she ended it, typical breakup bullshit, type, thing, not as relationship, friends with benefits, women, before, platonic. And many of those words are just sort of placed on the page, not as if they were in sentences.
To be clear, too, as we get to this last page, page 14, you had been asked about by Mr. King, Dr. Woodcock's ultimate opinion about sanity. Do you remember that?
Yes.
Yeah. So back here, when he's generating these 14 pages of notes on the July 24th-ish, 2012, is there any suggestion in there that the defendant lacks the capacity to know right from wrong based on societal standards of morality?
Judge, objection. This was asked and answered on direct examination. Ad nauseum.
Overruled.
No, one other thing is interesting to me. You asked about the way he structured the exam.
Yes, sir.
It appears...
Objection to speculation
Okay.
as to what appears.
Sustained.
Can I follow up on that, Your Honor, to see if I can lay a better foundation? What you were going to say when you said it appears, are you trying to interpret whether there was a structured flow to this interview and how it addressed certain issues?
No, and I see now by going back to the page before that my speculation would have been wrong.
Good. I'm glad we didn't do
It
it.
refers to something else altogether, what I was going to mention.
Now, at this time, though, Dr. Woodcock does sort of come up with an initial set of diagnoses.
Yes, he does.
Tell us what they are.
There's a reference again to something Mr. Bishop said just above that, if that's relevant. You asked me about Mr. Bishop's comments.
Objection, non-responsive to the question.
He's asking for clarification to the question. So, Mr. Bruckler, go ahead.
Yes, sir. My question was not about Mr. Bishop, it was
Okay.
about his diagnoses. But since we're there, is there another indication that Mr. Bishop injected himself into this in some way?
There's the words SB, parentheses, Kevin Bishop, initially called him Stephen Bishop. Others are safe around him if they don't do anything to warrant a response.
Okay.
I don't know when that was said or how it was said or if it was said in exactly that way.
Let's talk about the diagnoses right below
Sure.
that. What does, at that point, right after that 3 hours of interview, what does Dr. Woodcock think is going on?
He looks at 4 general diagnoses and then arrives at 2 of them. He looks at schizoaffective disorder, anxiety disorder, a couple of kinds, features of obsessive-compulsive disorder, but he calls those minimal, and major blunting of affect, that is, the way your feeling shows in your face. The primary diagnosis that he writes down at that point is, he says, schizoaffective disorder is primary, APD, which stands for antisocial personality disorder, is secondary. Then he has a question mark for sociopathic personality disorder.
Does he also say, after the major blunting effect, essentially sociopathic lack of empathy?
Yes.
Now, let's be fair. You've looked at all those. Do you agree with any of those, even as they were back on July the 24th, 2012?
Certainly not with schizoaffective disorder and certainly not with antisocial personality disorder.
Okay. So that's all the information we have about what took place on July the 24th, 2012. Is that right?
If one includes my conversation with Dr. Woodcock by telephone and his interpretations of it in his report, you're correct.
Now, you were asked, what would you do in this situation? And I want to ask you, if some 30-plus months later, someone had said, Doctor, we now want you to opine on the ultimate issue of sanity, what would you have asked to do in order to formulate a competent opinion?
Review as many relevant records as were available. See him again, not so much to try to recreate the past because I saw him back then, but it would be simply the thing to do to see him again, to see if any other useful information would come out, and then write a report as best I could given that bulk of information.
Now, in this particular case, Dr. Woodcock did see the defendant again?
After the date of the report, I believe.
Hang on. The report was March 26th. Is that the report where Dr. Woodcock renders the opinion that the defendant was insane under Colorado law?
He renders such opinions March 26, 2015.
And when did he see the defendant between July the 24th, 2012 and March the 26th, 2015?
Between July 20, 2012, did you say? On July 24, 2012.
In between July 24th and that report where he says that the defendant is insane on May 26th, when did Dr. Woodcock meet with the defendant?
I'm not aware that he met with him at all, and I'm under the impression he did not.
He met with him for how long when he ultimately met with him after July the 24th, 2012?
I think 1 hour. Let me just be sure based on his April 1st report. One hour.
And that 1 hour meeting occurred how long after he opined on the defendant's sanity?
Objection as to the timing of the opining.
Sustain as to the form of the question. Rephrase your question.
Doctor, do you know when Dr. Woodcock says he met with the defendant for 1 hour after the March 26, 2015 report that contains his opinion on sanity?
The strong implication is that it was on April 1st, 2015, according to a note or report that he titles Forensic Neuropsychiatric Interview.
5 or 6 days after he generated the report.
That would be 5 days after he generated the March 26th report.
Do you have any indication from talking with Dr. Woodcock or any notes or reports that other than those combined 4 hours over those 33 months that he met with the defendant and spoke with him to have any other additional questions asked?
I don't know one way or the other.
You've seen nothing that indicates that?
That's correct.
Okay. Can I have a moment, Your Honor?
You can.
And I'm going to turn off the...
All right.
Doctor, I don't want to spend a long time on this, but it was part of the cross-examination, so I feel like I want to address it, and that is this issue of malingering. Do you remember Mr. King going over that with you?
Sure.
It sounds like what you are saying, based on all the questions and answers with the defense, is that these validation tests and interviews are foolproof and no one can be fooled. Is that what you're saying?
No.
These are not unbeatable tests?
They're not perfect tests. There are lots of them. The bulk of them, the quality of interpretation of them, the combining of them with corroborating information, and the overall impression that I have and other people have had with him suggests that there's a very, very low chance. Can we be fooled over everything? I suppose anything's possible.
You've heard of that before?
Not with this bulk of care given to it. Now, are there some inconsistent things that have been said? Are there some things that may be said appearing to help his defense or something like that? Sure, that's true of everybody. But I don't know any reasonable examination test. I just can't think of any reason to believe that malingering is even a marginally significant part of the case.
Thank you, Doctor. One last little area here. Do you remember when Mr. King asked you about the quantification of your opinion based on reasonable degree of certainty in your field of expertise, and he asked you, is it 51%? Can we say it's 51%? Do you remember that conversation?
Yes.
I don't think I can give you or get from you a specific percentage, but I want to ask you a question related to it, and that is this. Based on the standards in the state of Colorado, the ones that the judge has given this jury, your opinion that the defendant had the capacity back on July 19th and July 20th, 2012 to know right from wrong based on the societal standards of morality, your opinion that he had the capacity to form the intent to murder after deliberation and to act knowingly, Do you have any doubts about his sanity on July 19th and July 20th, 2012?
Judge, I'm going to object. May we approach?
Yes. Okay, the objection by Mr. King is sustained. By Mr. Bruckler, you may proceed as we discussed at the bench.
Thank you, Your Honor. Doctor, I'm going to ask you 3 questions about this. How confident are you, in your opinion, that on July 19th and 20th, 2012, the defendant had the capacity to know right from wrong based on social standards of morality?
Extremely confident. I have no reasonable doubt.
Let me ask
Judge,
you...
objection. May we approach?
Yes. All right, members of the jury. Okay. Members of the jury, the objection is sustained, and the last part of the answer is stricken, and you should disregard it. You should treat it as though you never heard it. Actually, let's strike the entire answer. I'm going to strike the entire answer, and so disregard the entire answer. I'm going to have Mr. Bruckler then ask the question again. All right? So, yes, I'll give you a moment. All right. Mr. Bruckler, you may proceed.
Let me back up and ask that same question again, hopefully the same question again. How confident are you, in your opinion, that on July 19th and 20th, 2012, the defendant had the capacity to know right from wrong based on societal standards of morality?
Extremely confident.
How confident are you that on those same 2 days, as the defendant went into the theater to pull the trigger more than 70 times, that the defendant had the capacity to form the intent to murder after deliberation and to act knowingly with regards to setting up the booby traps in his apartment?
Extremely confident.
And finally, Doctor, how confident are you that on July 19th and 20th, 2012, the defendant was legally sane?
Extremely confident.
I have nothing further, Your Honor.
All right. Mr. King, do you have cross-examination?
I do, Judge.
You may proceed. And I meant recross, sorry. Go ahead.
And I'll try to be brief here, Judge.
Thank you.
Doctor, you were asked about an incident that took place in the jail in August, where Mr. Brockler asked you a question about trying to remove some screws that were on a safety bar in Mr. Holmes' cell, him trying to do that. Do you remember that line of questioning?
Yes, I do.
And do you have an independent recollection of this?
I did not. I saw the, actually, I don't have an independent recollection of the bar. I saw Dr. Mosier's note again describing 3 incidents like that, taking the screws out of something else, and I saw a video about the chain.
Are you aware then that when asked by deputies, Deputy Laughlin, what he was trying to do with the spoon in his cell, Mr. Holmes told Laughlin that he was attempting to remove the screws from the handicap rail to, quote, get metal.
I don't recall that phrase.
When Holmes was asked what he needed metal for, he told Laughlin, quote, to have metal.
I don't recall that phrase. It's beginning to seem familiar to me, but I don't recall the phrase.
Does that seem like an odd response?
It seems mostly like a response of somebody who is bored, trying to fill his mind or amuse himself in some way. I don't know what he meant by get metal to do what. There is a way of seeing that as an odd response. I agree with you.
What if what he meant by that was he was attempting to get metal because he thought historically societies that had metal had more protection?
In that case, it would be,
I'm asking as a hypothetical, Judge.
I'll then rephrase the question because I didn't understand that as a hypothetical. So the
Hypothet-
objection is sustained, but you may rephrase it.
Hypothetically, if he was removing that and said he needed to get metal, and the reason that he wanted metal, he said, was because historically societies that have metal have more protection and strength. Would that be interesting to you?
it would be interesting. It sounds like an odd response. I don't know any more context. You haven't described in a hypothetical any other context, but it sounds pretty odd.
Now, Mr. Holmes is in his, Mr. Brockler said that there's some indication that he said that that was for a club. Is that right? You remember Mr. Brockler?
That was the implication that Mr. Brockler said, yes.
Now, Mr. Holmes is in his cell all by himself 23 hours a day. Is that right?
Yes,
And on the hour that he can leave his cell, he's all by himself then, too.
that's my understanding.
In the entire time he's been in the county jail, he's never had any contact with any other inmates, has he?
That's my understanding.
You were asked, sir, about November 2012, and you were asked about delirium and psychosis. Is that right?
Yes,
In your opinion, based upon and the opinions of the doctors that were there, was that Mr. Holmes, when he was admitted to the hospital, had a combination of symptoms. He was exhibiting and had been for days psychiatric symptoms, which had caused him to stop drinking because he was paranoid about the food and the water. And as a result, he had some dehydration, which may have caused a delirium, but may not. Are you aware of that?
my interpretation of the record was that he did have a delirium when he got there, and that one of the likely causes, according to the record and according to the doctors, was that he hadn't been drinking or eating properly. It follows from that, I believe, that the reason he wasn't drinking was likely a psychiatric one, like a paranoia about the water. I don't know any more about it than that without speculating.
Have you seen the blood work from Mr. Holmes from the hospital?
I saw it, do not remember it, and would not be the person to interpret it.
You said that delirium clears very quickly when the person is rehydrated and his metabolites come back in order and such.
When the source of the delirium is removed, assuming there hasn't been brain damage, the cognitive ability comes back quickly.
Now, you said also if it's a first break psychosis and sometimes a second break, that the application of antipsychotic drugs can clear the psychosis rather quickly. Is that fair to say?
In some instances, yes. In some, no. Vigorous application of treatment, including medication, tends to clear psychosis more quickly in early breaks, first break, second break, than in fourth, fifth, sixth break.
Are you aware that Dr. Gurr visited Mr. Holmes in the jail on December 19th, 2012?
I, for some reason, thought it was December 12th or something, but that's about when I understand that she was there, yes.
And she was told that he was still experiencing hallucinations, seeing shadows, things like that, correct? Do you recall that from her report?
I recall him appearing more symptomatic to her than he appeared to me. And what you say makes sense. If it's in the record, it's in the record.
Do you recall her indicating that he continued to have visual and audio hallucinations in the jail for a month after receiving the antipsychotic medication, and that then those symptoms subsided?
Something like that, yes.
You were asked if in the weeks and the months following, if he had any other similar problems. Do you remember that question?
I was questioned on that, yes.
Do you recall that in the month of January 2013, Mr. Holmes was again placed in the rubber room for suicide reasons?
I do recall that, and I had forgotten, but I knew that, yes. It wasn't necessarily for psychotic reasons. My understanding is that it was because he expressed suicidal thoughts.
You were asked about Mr. Holmes saying that he experienced these intrusive thoughts of killing since he was a child as a sound, like a voice inside his head. Is that right?
Overruled.
I recall him saying that it was as if something inside were telling him that. I don't want to confuse that with him hearing a voice, because I very carefully attempted to figure out whether it was a hallucination or not, but I recall him saying something like that.
And I'm attempting to clarify that.
All right. Sure.
It's clear to you, based upon what he told you and based upon what he told the other clinicians, that he did not report hearing a voice, but he reported that it was like a voice inside his head telling him to kill people. Correct?
I think those are very similar to the words that he used with me.
Like a command thought.
I don't know what you mean by a command thought. If you mean a command hallucination, it wasn't a command hallucination. I don't know any psychiatric definition for command thought.
Okay, thank you. You were asked about how there may be no way to disavow Mr. Holmes' belief that there's human capital. Gaining human capital causes you or killing people causes you to gain human capital. That there's no way to disavow that. That's what Mr. Brockler asked you. Is that right?
Yes, I can't think of a way to show that to him.
Well, Mr. Holmes is present in court, right?
Yes.
He's been present throughout the proceedings in this case, right?
Yes.
He's aware of what you and the other doctors think about the human capital concept.
Yes. Yes.
He's aware that you and the other doctors and the rest of the people in the world don't think that it's a valid concept, right?
Right.
And yet, 3 years later, in a medicated state, he continues to have that thought and belief in the face of all that he's been told. Correct?
So far as we know from what he says, you are correct.
You were asked if somebody wanted to go into a theater and said, or someplace, and said, killing, for every person you kill, you're going to get $1 million. Is there any indication that Mr. Holmes thought he was going to get money or any other tangible benefit for the shooting?
None.
You were asked about disorganized speech. Is that right?
Yes.
Disorganized speech in the DSM-5 comes under the category of disorganized thinking. Isn't that right, sir? I'm on page 88.
Sure. The inference being that one of the ways to infer disorganized thinking is if the person's speech is disorganized.
That's right. What the DSM-5 says is disorganized thinking is typically inferred from the individual's speech. Is that right?
Correct.
The fact that there isn't disorganized speech doesn't indicate necessarily that there isn't disorganized thinking, does it?
Actually, I can't think of a situation where that's the case. The reverse is the meaning of this paragraph, I believe. That is, if a person is mute, for example, then you need to use other indices of disorganization, or in addition, that's what I meant. I'm not aware of a situation in which a person spoke in an organized fashion and didn't have organized thoughts. It may exist, but I can't picture it.
You were asked about Squarespace.
Yes,
And it was pointed out that he put the website address to the Squarespace page on the last page of the notebook.
apparently so. I mean, I saw it on the last page, yeah.
Now, if the website that is the location for is not able to be accessed by anyone other than Mr. Holmes, putting that in there may be an example of disorganized thinking.
I wouldn't make that inference. First of all, I don't know that it's not accessible. I suppose it might be the wrong address, or it might be password protected. I don't know why it's there, and to infer that it was there as an example of disorganized thinking wouldn't occur to me at all.
Excuse me. You were asked about Dr. Woodcock. Now, were you there for the interview that Dr. Woodcock did?
No,
Do you know what the conversation was like?
only from the notes and what Dr. Woodcock says. I wasn't there.
You said that you would prefer to do an interview in private without anyone else being there, correct?
Correct.
Now, you, when you had your job as the head of mental health for the state of Texas, you said that you sometimes saw patients with other clinicians to assist them in their work. Is that right?
Sure.
Fenton and Feinstein saw Mr. Holmes together so that they could corroborate on their work and assist each other. Is that fair?
In the treatment effort, sure.
You have described Mr. Bishop as an investigator. Are you sure that's what he is?
He was represented to me as an investigator when you or one of your colleagues introduced him to me, as I remember.
Do you know what his degree is?
No, I don't. Social work, as a matter of fact, I think, isn't it?
A licensed clinical social worker.
Okay.
And you have previously described these as mental health professionals that treat and diagnose individuals with mental illness. Is that right?
Yes, as long as they're clinical social workers, sure.
You don't know why Mr. Bishop was there, do you?
I don't know why he was there. All I'm referring to is in the forensic context, I have preferences that I believe in and teach. In a clinical context, it is quite different.
You don't know what, if anything, Mr. Bishop injected into that conversation, if at all, do you?
Only as it appears to be represented in the notes, and you'll have to ask Dr. Woodcock or Mr. Bishop.
But very unclear. Question mark, Bishop, cough, laughing, for example.
It's unclear. I don't know that it's very unclear when one considers the three examples, but once again, I'm happy to defer to either Dr. Woodcock or Mr. Bishop.
You don't know what Dr. Woodcock, was asked to do by the attorneys when he visited Mr. Holmes in the jail that day, do you?
No, I don't.
You don't know what the questions presented were, do you?
No, he may have said something to me, something may be in my notes, but as I sit here, I don't know what you asked him or told him to do.
And you don't know what legal constraints there may have been at that point, just days following the incident, regarding discussing matters with Mr. Holmes or not, various topics.
I don't know.
You were asked from the notes about option A, B, and C. Option A being succeed in the therapy, option B being the annihilation, nuclear winter, and option C being the shooting in the theater, correct?
Correct.
That's very, very similar to what Mr. Holmes told you. Is that right?
Yes, it is.
You were asked if the word in Dr. Woodcock's notes, it was brought out by Mr. Brockler through you that Mr. Holmes used some phrase talking about a hatred of people. Is that fair?
Yes. I hate people, or I hate everyone, or something like that, yes.
That sounds a lot like what he wrote in the notebook when he talked about a hatred of mankind.
There's a similarity, sure.
And he never wrote the words broccoli or aversion in the notebook, did he?
I'm not sure whether he wrote aversion. I know he didn't write broccoli.
The way that the words aversion and broccoli came up is when you asked him to describe what this hatred of mankind or of people was like. Is that right?
Yes.
And he described it as an aversion to people like you hate broccoli, not like you hate in an active kind of way. Fair to say?
Fair to say.
You were asked about whether or not there was any mention of human capital in Dr. Woodcock's notes, right?
Yes.
What was written in Dr. Woodcock's notes was a phrase like, I turned them into numbers, right?
That phrase was there, and not particularly in a context, but that phrase was there.
When Mr. Holmes described the human capital concept to you, he described it as gaining a point, a number. Is that right?
Yes.
Now, you were asked about what you would want to do if you were later asked to render an opinion, if you'd seen someone initially and were later asked sometime later to render an opinion on sanity or other opinions in the case, correct?
Correct.
And what you said was you would want to, number one, review all the relevant records, correct?
Correct.
You would and let's be clear, you don't know what Dr. Woodcock does for a living other than work on this case, right?
I don't know Dr. Woodcock personally, not at all.
You don't know whether he has a full-time job running Alzheimer's clinic at Anschutz Medical Center?
I may have his CV, but I don't know him and don't know what he does day to day.
You don't know what his schedule was like, do you?
No.
Now, if he was to review all the relevant records, when was your report and videotaped interview available for review?
You mean to send to people such as you guys to
Yes,
review?
sir. Yes, sir.
Some weeks afterward, I think. I don't know exactly how long it took us to create the videos and create the transcript.
And you don't know how long it took to review those 20-some odd hours of videotape for Dr. Woodcock?
I don't know. I know that he looked at them because he refers to them, but I don't know how long he took. No.
You don't know how long it took him to review all of the other materials in the case, which are vast. You would agree?
I would agree, and I don't know how long it took.
You said you would see him again, and Mr. Brockler made some issue out of the fact that this report was apparently drafted, or the date on it is March 26th, and it was a day or two later that Dr. Woodcock actually visited Mr. Holmes in the jail, correct?
Give me a second. The objection is sustained. Rephrase your question, please.
Sure. You were asked questions about the timing of the report draft and the second visit with Mr. Holmes, correct?
Of the report, to the extent that the report was a draft, yes.
And that was going to be my question. You don't know whether that was a draft report that was written anticipatorily, and Dr. Woodcock was waiting to see Mr. Holmes to either confirm or not whether the visit supported what his positions were based upon his initial visit with Mr. Holmes and based upon his review of all of the materials, including your extensive videotape contact with Mr. Holmes.
There's no indication on the first page in the title, in the introduction, etc., that it was a draft or that he considered it a draft. On the last page it says, I reserve the right to amend these opinions should other relevant information become available. There's nothing that says draft on the report.
You don't know whether it is a draft or not, do you?
My assumption, and it's just an assumption, is that when one writes a draft, one says it's a draft.
You don't know whether it's a typographical error, do you?
Anything's possible.
That's my point. You're speculating based upon the date of the report what happened, and you don't really know what happened, do you?
I'm reading what the report says. That's all I'm doing.
And there was some indication about the tardiness or the lateness of this report or this opinion. You're aware, sir, that the prosecution has retained a psychiatrist named Dr. Wellner. Is that correct?
I'm aware of that, yes.
Yes. All right, the objection is withdrawn. Mr. King, go ahead.
You're aware that Dr. Wellner has now rendered an opinion about whether he believes Mr. Holmes is sane or not without ever meeting with Mr. Holmes one time, correct?
So far as I know, he has not seen Mr. Holmes, and I'm aware that he has rendered opinions.
I have no further questions.
All right, let's see if the jury has questions for Dr. Reed. Dr. Reed, the jury may have some questions for you, so I'm going to ask you to I'm going to ask you to stick around.
Sure.
Given the number of questions that are being passed down, I think what we'll do, folks, is have you go on break for about 10 minutes. I think we can run through them, and then I'll bring you back in here as soon as I can. We have to talk about all of them. I'm going to try to get you out of here by 5:30, but I have to get through these questions, so I'll do the best I can. Remember that my advisements apply during the break. Thank you. Thank you. And Dr. Reed, I'll have you step out as well, please. The record should reflect that the jury has exited the courtroom. The record should also reflect that Dr. Reed has left the courtroom. Everyone may be seated. The first question submitted by the jury for Dr. Reed is on the form that I marked as number 163, and the question is, what were the defining factors for you to diagnose the defendant with schizotypal personality disorder instead of schizophrenia or schizoaffective disorder? Any objection? Mr. King? Okay, no, he said no. All right, I'll ask it. Next is on the form that I marked as 164. There are a couple of questions on this form. The first question is, in your expert opinion, how likely or strongly do you feel if the defendant were released into free society based on his belief that human capital adds to his self-worth and value and his continued contemplation of suicide, that the defendant would seek to add additional human capital and/or value to his human self-worth and/or value. Mr. Brockler?
I'd like to know the answer, Judge, but I think it's probably more appropriate at best for rebuttal and sentencing if they get into risk of future dangerousness, that kind of stuff.
If we get to that point, you may be right. Go ahead.
Well, Judge, I object. If you want to hear more argument, that's fine.
No, the objection is sustained. I will not ask this question. The next question is, in your time with the defendant, do you feel he had a problem or issue with advocating for himself, especially when he felt strongly about something? Mr. Brockler?
No objection.
Mr. King?
No objection.
All right, I'll ask that question. The next question is on the form that I marked as 165. The first question on that form is, the defendant often answer your question with, I don't know or I don't remember. In your opinion, do you believe that he doesn't remember or that he is avoiding the questions or possibly another reason? Mr. Brockler?
Have a moment, Your Honor.
Yes.
Sorry, Judge, it sounds like it's asking for him to determine his credibility when he says those things, and I think we've been pretty clear he's not allowed to do that.
I agree.
I agree. I'm not going to ask that question. The next question on the same form is, in your opinion, if the defendant hadn't been arrested, do you believe he would have planned another mission? Mr. Brockler, I'm assuming you object. Mr. Brockler?
Yeah, I wanted to think about, yeah, Judge, I think it's been proper.
Mr. King, you agree?
Yes.
I agree as well. I'm not going to ask either one of those questions. The next question is on the form that I have marked as number 166. The question is, the defendant mentioned during the interview that he broke off the relationship with the CU student he went hiking with because he didn't want her to be deemed the girlfriend of a murderer or something similar. Do you have any comments relating to culpable mental state, forming intent, or knowing right from wrong as it pertains to this statement?
No objection.
Mr. King?
Judge, I would object. That doesn't call for an opinion that he can legally give under the law. It's not talking about capacity. It's talking about the mental state, which the jury has to decide.
I think this question is trying to ask whether that has any impact on his opinions. I think if rephrased that way, I think it's a fair question, so I'll rephrase it that way. So I'm going to change this question by modifying the last part of it and asking as follows. Does that have any impact on your opinions regarding capacity to distinguish right from wrong and capacity to form the culpable mental state elements of the offenses charged? All right, the next question is on the form that I marked as 167. The question is, you mentioned that increasing self-worth was not rational or logical. However, from a clinical standpoint, could increasing Mr. Holmes' self-worth be a logical explanation if he believed that killing a large group of people would make him be remembered in the likeness of the pictures he posted, or alternatively as a murderer? Mr. Brockler.
No objection.
Mr. King.
I would object to the question. First of all, it's calling from a clinical standpoint. I don't think that this expert is in a clinical position.
Well, this expert has testified about whether the concept of human capital is a rational or logical concept, and this is asking about whether his opinion related to that changes if it is understood in the way that it is explained here, or if the defendant believed what it is asking about here, and that is being remembered in the likeness of the pictures posted, or alternatively as a murderer, to quote the question. I will take out the part about from a clinical standpoint, because frankly I'm not sure what the juror means by that, so I'll take that out, but I will ask the question otherwise. The next question on this form is, could Mr. Holmes have wanted to get metal for suicidal purposes? Mr. Brockler? I think it calls for speculation.
It calls for speculation.
You agree as well, right?
Yes.
All right, I will not ask that. The next question is on the form that I have marked as number 168. This form has 3 questions. The first question is, if a person such as the defendant is facing huge prospects of possibly never getting out of prison or facing the death penalty, from a mental health standpoint, could someone act out because of that fact in a manner that is self-destructive, such as Mr. Holmes did on the days in November 2012 when you viewed the jail videos? Mr. Brockler?
No objection.
Mr. King?
I'd object that that calls for speculation. There's no indication that that's from any of the questions or answers that have been given that that had anything to do with it.
I'm going to sustain the objection because this juror is asking for an opinion from a mental health standpoint, and I don't think the doctor can give that opinion. I think this goes to argument. I mean, obviously the parties can argue during closing that that video should be interpreted differently, or that the jury should take into account Mr. Holmes's current situation or the situation at the time in November 2012 and decide whether he faked that or not. But I don't think it's appropriate for this expert to say from a mental health expertise point of view whether that's something that he has an opinion on. All he could say is it's possible, but that's the same thing all of us could say, or anyone could say. Anything is possible, so I won't ask that question. The second question on this form is, could some of Mr. Holmes's actions in the videos in November 2012 have been suicidal rather than psychotic episodes, given his future legal prospects? Mr. Brockler?
No objection, Your Honor.
Mr. King?
Same objection, Your Honor.
Same ruling. I think it's along the same lines. It's asking, is it possible that this was what I don't like about it is the last part of it, the given his future legal prospects. What if I ask the question without that last part and just ask, could some of Mr. Holmes's actions in the videos in November 2012 have been suicidal rather than psychotic episodes?
No objection.
Mr. King?
Same objection, Your Honor.
What's the objection with respect to that question? I mean, if he's viewed the videos and he's been asked questions about whether that is consistent with a psychotic episode, Your experts have been asked that question too. So why is that an improper question?
It's the same as before. Could it? Yes, it could. It's possible. The doctor has already opined that he believes that Mr. Holmes was floridly psychotic at that time. So it's clear what the doctor's position is, that it's due to psychosis. That's what the doctor testified to. I mean, the question is just, is it possible? And like you said on the previous question, the only possible answer is, yes, it's possible, because anything's possible.
I'll sustain the objection. Mr. Holmes King has persuaded me. The next question on the same form is, how did you arrive at the conclusion that Mr. Holmes did not have antisocial personality? Can you elaborate on this as it relates to the insanity defense? Can people with antisocial personality know right from wrong? That's like a three-part question. Mr. Bruckler?
No objection.
All right, Mr. King?
No objection.
All right, I think it's an appropriate question. On Form 169, the first question is, can isolation, as in jail, alter behavior? If so, how? Mr. Bruckler?
To the extent that he knows, no objection, Your Honor.
Mr. King?
I'd object as beyond the scope of his expertise, Judge. He hasn't let us know that he's any kind of expert in prison or isolation or any of that. Dr. Metzner is, but he's not.
I think he testified about this anyway. I think he said he took into account the fact that 2 years have passed, or more than 2 years have passed, the fact that the defendant is now on medication, the fact that he's been in the jail in isolation. So I will sustain the objection. The next question is, can the way questions are asked sometimes alter how things are remembered? I think he mentioned this already, but do you have any objection, Mr. Bruckler?
I don't, Your Honor.
Mr.
No.
King? All right. The next question is, can self-diagnosis, like Mr. Holmes's did, cause at least temporary symptoms? Mr. Bruckler?
Objection, Your Honor.
Mr. King?
Judge, I object. I don't understand the question. Can self-diagnosis cause symptoms? Diagnosis is just a description of what you think the symptoms are. So I would object as inappropriate, calling for speculation, and I don't know that this doctor can opine to that.
Your Honor, may I supplement just a little bit?
Yeah.
What it sounds like to me is that they're asking, if someone concludes that they have something, can that cause them to begin to act in a way consistent with that conclusion? That's what it sounds like it's written down as.
That's how I read it too. I'm going to overrule the objection, but instead of cause, I think I'm going to change that to result. Can self-diagnosis, like Mr. Holmes did, result in at least temporary symptoms? Is there any objection, without waiving your objection, Mr. King, is there any objection to me redacting it that way?
Yes, Judge.
You would prefer cause?
I think that you have to ask the question. If you're going to ask the question, you should ask the question the way the juror wrote it.
Well, I don't know that that's true. We've been modifying in the past, as you know. But given your position, I'll leave it as is, so I will ask it over your objection. And then the final question is on the form that I marked as 170, and the question is, how do you distinguish a difference between delirium and any other conditions with similar symptoms after the fact? That is to say, how did you come to the conclusion that the defendant was delirious when taken to Denver Health and not something else? Mr. Bruckler?
No objection.
Mr. King?
Judge, I would object. I think that that's been asked and answered. The doctor has testified very clearly on both direct and cross-examination that he believes, based on the record, that Mr. Holmes was both delirious and psychotic when he was admitted to the hospital.
The objection is overruled. I think part of the reason why jurors are allowed to ask questions in Colorado is because sometimes they might miss something. This doctor has been testifying now for a week. That's a long time, and it's possible that someone missed something. So I will ask it. All right, let's bring the jury back in, please. Please be seated, everyone. The record should reflect that the jury's back in the courtroom. Folks, thank you very much for your patience. We're only going to stay here until 7, so we should be able to let you go here soon, but thank you for your patience. The record should reflect that in addition to the jury being back in the courtroom, Dr. Reed has resumed the witness stand. Doctor, I will remind you that you're still under oath. The jury has submitted some questions that, based on the rules of evidence and other applicable rules of law, I have determined are appropriate. I'm going to ask those questions now.
Yes, sir.
The first question is, what were the defining factors for you to diagnose the defendant with schizotypal personality disorder instead of schizophrenia or schizoaffective disorder?
The main factor was an absence of things that I associate with schizophrenia and schizoaffective disorder. As you may have noticed from the exhibits, he meets the criteria, or met before July 19, 2012, met the criteria for schizotypal personality disorder quite well. The question to me and to others is, does he have enough other symptoms to make schizophrenia or schizoaffective disorder a logical diagnosis? I saw no acute psychosis as at least until July 19-20 of 2012, and it seemed to me that it was a better fit to be schizotypal personality disorder. In terms of schizoaffective disorder, that's a considerably more serious disorder that requires both a diagnosis of schizophrenia and, in addition, a diagnosis of a severe mood disorder or mood episode. Can be a depressive one called major depressive episode or major depressive disorder, which is a real severe kind of depression. Or it could be something called a manic disorder or manic episode. And the mood disorder has to coexist at the same time as an acute phase of the schizophrenia. I simply did not see that any of that was present prior to July 19 and 20, 2012. It gets a little bit more complicated, if you will, after that, as one comes up through November of 2012, when he clearly had a psychotic break, and the probability of his having or developing schizophrenia becomes higher in my mind. And as I mentioned earlier, I wouldn't argue with someone who wanted to call the period prior to July 1920, who wanted to call that early schizophrenia or pre-schizophrenia, but I don't believe the schizophrenia itself had developed by that time.
The next question is, in your time with the defendant, do you feel he had a problem or issue with advocating for himself, especially when he felt strongly about something?
His communication was not good in terms of expressing strong feeling on lots of topics. I believed that he was quite able to communicate what was in his mind. We've kind of talked about what may have been inside him that he wasn't aware of, unconscious kinds of things that can't get out. My interest is in part in seeing how he is psychiatrically, psychologically, and in part in trying to determine and hoping that what he says is reliable. I don't believe that he had any problem with that reliability part. Are there things that he wasn't able to share with me? I believe because of psychological factors, yes.
All right, would counsel please approach for just a moment? Thank you, folks. All right. Doctor, the next question is as follows. The defendant mentioned during the interview that he broke off the relationship with the CU student that he went hiking with because he did not want her to be deemed the girlfriend of a murderer or something similar. Does that have any impact on your opinions regarding capacity to distinguish right from wrong and capacity to form the culpable mental state elements of the offenses charged?
Those statements, those series of statements that are represented several places in the record, suggest to me that he was considering something that might have hurt the other person, and that, if I can remember, they were a point toward him having such a capacity. It's only one item, but they're a point toward him having such a capacity simply because he wanted somebody else to be careful. He wanted to protect somebody else from something he thought might be harmful or hurtful to her.
The next question, Dr. Reed, is you mentioned that increasing self-worth was not rational or logical. However, could increasing Mr. Holmes's self-worth be a logical explanation if he believed that killing a large group of people would make him be remembered in the likeness of the pictures that he posted, or alternatively, as a murderer?
I think Mr. Holmes' feeling of self-worth is very important to him. You heard him say in some of the interviews that it felt bad not to have been, for example, invited back to try again to stay in graduate school. They were open to him staying, but he wasn't invited. I guess it's better to be invited on a date than to ask for the date. I think that's important to people. I think it's important to Mr. Holmes. I don't think it's coincidence that he spoke of feeling valued or not feeling valued, and he also uses the word value when he talks about those points. I have 13 points of value. I have a higher value than I had before. It's tempting to say, and I don't think it's entirely speculation to say, that...
I want to object to any speculation.
Sustained. You can't speculate.
I understand. Okay, thank you. His statement that he is now valued more highly as a 13 rather than a 1 appears to me to be associated in some way with his statement that he wants to be valued more, for example, at school and in several other parts of his life. There was a second part to that question, and I'm sorry I forgot it.
I'll read the whole question to you again. The question is, you mentioned that increasing self-worth was not rational or logical. However, could increasing Mr. Holmes' self-worth be a logical explanation if he believed that killing a large group of people would make him be remembered, and remembered is in quotes, in the likeness of the pictures he posted, or alternatively as a murderer?
I think more in terms of gaining value being a motivation, and a rational motivation within that context. I'm not saying that it's rational to think that he would gain value, but his wish to be valued more, I think, is one of the motivations for what he planned and what he did. In terms of being remembered as a murderer, I don't know whether when he was planning it, he was thinking about being remembered as a murderer.
The next question is, give me just a second. I'm sorry, Counsel, can you approach, please, for just 1 minute? Thank you. All right, Doctor, the next question is as follows. How did you arrive at the conclusion that Mr. Holmes did not have antisocial personality? Can you elaborate on this as it relates to the insanity defense? And can people with antisocial personality know right from wrong? And if you want me to repeat any part of that, I'm happy to do it.
Thank you. Antisocial personality has been a clinical interest of mine, a research interest for a long time. People with antisocial personality disorder don't have a problem in thinking the way people with schizophrenia or some people with schizotypal disorder may have. It's a disorder that's characterized by trying to get what you want from other people or from the world without regard to what they want, without regard to their feelings. We think of common criminals as having antisocial characteristics, and some of them have antisocial personality disorder. In my view, it's very difficult for a person with antisocial personality disorder to not be able to form the capacities that we think about for responsibility for one's crimes or one's acts. And in every state I know of, people with antisocial personality can't use that as a diagnosis to form an insanity defense. It's simply not legally, I'm not a lawyer, but it's not legally considered eligible for the concept of legal insanity.
The next question, Doctor, is can the way questions are asked sometimes alter how things are remembered?
Sure. The way questions are asked can alter the way the answer comes out. I'm sure pretty much everybody in the room has had that experience. If a question is asked over and over again in a certain way, it seems logical to me that parts of the question may sort of become parts of memories. And you may have seen a little bit of that when Mr. King was asking me questions earlier today. I don't want to confuse that with other ways of altering memory. I don't think it's the big way that you alter memory. But for example, if one asks a question, particularly under hypnosis or when a person's paying great attention, you remember that time you were at the Dairy Queen, don't you? You sort of start out thinking there must have been a time I was at the Dairy Queen.
The next question is, can self-diagnosis, like Mr. Holmes did, cause at least temporary symptoms?
The answer is yes, to an extent, and it depends on what you're self-diagnosing. If I'm convinced I have a stomachache, I may end up with a stomachache. If I'm convinced that the mold outside is going to cause me sinus problems, I'm probably more likely to get the sinus problems. So that when a person engages in lots of self-diagnosis, and you might talk about somebody who's a hypochondriac or something like that, symptoms sure may crop up. And sometimes those symptoms may be quite genuine, and a doctor would recognize them too. I'm not sure I'm answering that question very well.
The final question, Dr. Reed, is as follows. How do you distinguish a difference between delirium and any other conditions with similar symptoms after the fact? That is to say, how did you come to the conclusion that the defendant was delirious when taken to Denver Health and not something else?
Part of the way I came to the conclusion was that other doctors who appear to me to be quite qualified at Denver Health came to that conclusion. And they described why, and I had no reason to doubt what they said. Delirium is a condition related to some acute change in the brain, usually related to something metabolic, can be something toxic, in which one loses his orientation. You're out of contact with reality, certainly, but it's because of, there's a word and it's not coming to me, there's a psychiatric or neurological word that's not coming to me, and this occurs when you're in what's called a clear sensorium, that is, you're not asleep or dreaming or something like that. I'm not saying that very well. There are other ways. All psychosis means is out of touch with reality. There are lots of ways to be psychotic. You can be psychotic because you're drunk. You can be psychotic because you're withdrawing from some particular substance. You can be psychotic because your grief is so great that you're just hysterical. You can be psychotic because you have a manifestation, an acute phase manifestation of a schizophrenia or a severe depression. There are lots of ways to be psychotic. It's a symptom. The way stomach pain is a symptom or high blood pressure is a symptom. It doesn't refer to some particular cause or some particular way to fix it. I hope that's helpful.
All right, any follow-up questions based on those questions and answers? Mr. Brockler.
Just a couple, Your Honor, if I could. Doctor, in relation to the question about the defendant being able to stand up for himself, did the defendant correct you from time to time on things that you said or had interpreted that he had said?
Yes, from time to time he said, no, that's not right, or I would say, do you agree with me? And he would say no. So he was able to, as you say, stand up for himself pretty well in all of our sessions.
Whether we believe that his interest in achieving an increased self-value by killing people, whether we think that was logical or delusional or whatever, did the defendant, in your opinion, set about achieving that in a logical way?
Yes.
Finally, as regarding, I think the last question, maybe the one right before that, whether what happened in November of 2012 was the product of a delirium, some other related psychosis, or both, does that have an impact on your opinion about the defendant's sanity on July 19th and 20th, 2012?
No, it does not.
Thank you.
All right, Mr. King, any follow-up questions from you?
Briefly, yes, Your Honor. With regard to your decision or your diagnosis of schizotypal personality disorder versus schizophrenia, sir, I believe your answer to the juror's question was you have no problem with other clinicians who would diagnose the period prior to July 19th and 20 as being early or developing schizophrenia with the psychotic state beginning after incarceration. Is that correct?
I would not have very much argument with that. I think it would be an academic argument rather than something related to the ability to form a capacity or something like that.
Right, and so you have no disagreement with the diagnosis of schizophrenia now. You just disagree with the diagnosis of schizophrenia on July 20th, 2012.
I might argue with the diagnosis of schizophrenia now, but there's considerably more evidence for it now than there was prior to July 20.
You were asked about antisocial personality disorder. Antisocial personality disorder requires someone to be diagnosed with a conduct disorder as a child. Is that right?
Yes, it does, and that's a good point. Antisocial personality disorder first requires a childhood diagnosis of a specific disorder, which Mr. King is correct, conduct disorder, and that has its own set of criteria that there is no evidence were present in Mr. Holmes. And next, as an adult, there have to be a number of other criteria which I have no question Mr. Holmes does not meet.
So there's no question that he had an antisocial personality disorder or conduct disorder as a child, and no indication, you're indicating no indication at all that he has antisocial personality disorder.
That's correct.
You were asked questions about Denver Health Medical Center and whether we can determine it was a delirium or a psychosis caused by a psychiatric illness. He was seen by several psychiatrists and other doctors while he was there, correct?
Correct.
He was there for days, correct?
Correct.
All of the psychiatrists that saw him felt that he had both a delirium and that he was psychotic from psychiatric symptoms when he was admitted. Is that right?
I think that's accurate, and further, the strong implication is that the delirium was caused by something wrong with him in his not, for example, drinking enough water.
And so what you're saying is that the psychiatric psychosis, the paranoia about his food and drink, preceded and actually may have caused whatever delirium he was experiencing when he was admitted to the hospital.
That's a logical assumption. I don't believe that the doctors at Denver Health found any other source, such as some noxious fumes or some kind of poisoning or something like that. I don't think any other source was found for delirium.
And he did report that he had not been eating later on because he felt that his food was being poisoned in some way or something like that, correct?
That's my understanding.
And so there's really no doubt. Well, first, whatever delirium existed cleared up fairly quickly, like you said it does. Is that right?
So far as I can see from the record, yes.
And the psychotic symptoms persisted for days while he remained in the hospital, and then, according to Dr. Gurr, continued for at least 30 days after he was returned to the jail. Is that right?
That's fair to say.
No doubt, then, that when he was admitted to the hospital, he was suffering from both a mild delirium and psychotic mental illness.
That's an opinion I would offer.
Thank you. I don't have any other questions, Your Honor.
All right, may Dr. Reed be released from his subpoena?
Your Honor, for another part of the case we made.
All right, so he's subject to recall.
Yes, sir.
All right. So, Doctor, you're subject to recall. Thank you very much for your time.
Thank you.
All right. Members of the jury, it's about 3 minutes after 6. I'm going to ask for 60 more seconds just so that I can run through these advisements, and I'm going to give them to you in summarized fashion. Number 1, please do not discuss any aspect of the case with each other through any means. Number 2, please do not discuss the case with anyone else through any means. Number 3, please do not talk to the witnesses, parties, or attorneys about anything. Number 4, please do not talk to any members of the media about anything. Number 5, please wear your juror badge at all times when you're on courthouse grounds and make sure it's visible to all those around you. Number 6, you must not read, view, or listen to any news or media reports that may refer to this case. There's media coverage of the trial, so please be particularly vigilant when listening to the radio, watching TV, reading the newspaper, and using the internet. Number 7, do not visit any locations that are mentioned in the case or conduct your own investigation outside the courtroom. Number 8, please don't start forming any opinions about the case. You must keep an open mind throughout the trial. Number 9, neither sympathy nor prejudice for the prosecution or the defendant may affect any of your decisions in this case. And number 10, remember that the attorneys have a job to do. Sometimes they're required to make objections and asked to approach the bench. Please don't hold it against them when they do that, and don't infer anything from any of my rulings. I'm trying to do my best to apply the law. And one last thing, remember that all decisions that you make in this case must be based solely on the evidence and information presented in the courtroom and the instructions of law that I give you. A bit of good news for you. We're a little bit ahead of schedule, so that's good news. And so we're going to keep with the schedule we've kept in terms of when you get here, how long the lunch break is, and when we go home, all right? So given that, have a great weekend. I'll see you back here Monday morning. Thank you. Everyone. The record should reflect that the jury has exited the courtroom now. Mr. Bruckler, you said, I think that you're planning on calling Dr. Metzner on Monday. I just want to make sure that he is aware of all my orders that relate to his testimony, so that he knows about all of the parameters that have been set in terms of expert testimony and mental health. Okay.
Yes, Your Honor, and
Please.
we've already sent to him those orders since what we did in here in the court regarding Dr. Reed.
Okay, great. All right. Anything else on behalf of the people at this time?
Your Honor.
And in addition to sending him those orders, it may make sense for someone to go talk to him about it and just make sure he understands exactly what the parameters are. All right?
Yes, Your Honor.
Okay. Mr. King, anything from you?
Thank you.
All right. Have a good weekend. I'll see you Monday. The court will be in recess.
Please rise.